Okay, welcome everybody. Yeah, this is a little unexpected today. I didn't expect to stream today, but unfortunately, it got late and the order just came through. So I apologize if it's was completely out of the blue. I kind of figured that there would be an order yesterday or today, but I was hoping to kind of be earlier today. It wasn't. It came through about an hour ago, and I spent the last I don't know what it was, half hour, 45 minutes. I was talking to my lawyer, getting the details. So there's a lot to go over here. I'm going to tell you straight up, it's a mixed bag. Now, the overall thing is excellent. I mean, it is fantastic for me. However, it sucks in the short term because I'll just give you the gist of it. We have to wait another 2 weeks. Okay, so yeah, that sucks. I'm not going to front waiting another 2 weeks when obviously Kyle's had 2 years. It's just nonsensical to me, and it just should be nonsensical to anybody. The system has fundamentally, failed in that regard. However, I do understand what the court is doing, and I understand why they're doing it. And I know there are some COVID reasons, and I know there are some restrictions when it comes to the hearings. They want to do a hearing as quickly as possible. However, the court is unfortunately still not open in the courthouse itself. What it is, it's at a law school, and so they can only have hearings at certain times, right? So unfortunately, we're just kind of basically bounded by that, right? So I'm going to go through the new order for you guys, kind of explain what it entails. Like I said, in the huge long run kind of stuff, this is the end of the line for Kyle, and it is excellence for us. There's no question about that. I will tell you in the very beginning here, there is being the DA involved. Okay, so I'm not going to give out too many details about that, but I think I at least should inform you guys that the DA will be involved in this. He is going to be, or she, I'm not sure actually if it's a he or she, but the DA is going to be involved in this. That is a guaranteed. So I will tell you guys that, but I can't, like I said, give up too many details for that. But obviously, there's some criminal aspects to be had here. Awesome. All right, so let's kind of go through this. If anyone wants to join me, I don't have any room open right now, but I'm fine if they do. I'll just open one. So let's kind of dive into this. So we were waiting for the order on our amended to show cause. Now, there was two actually things going on. We have a order for a criminal hearing for the submission of altered evidence as far as the willful interference of the court. That has not been ruled upon yet. Honestly, I don't know why. My lawyer doesn't know why either. We don't understand what the holdup on that one is. We think because it is such a criminal aspect that they're waiting for all this to be settled first. Well, it's just fine. However, Kyle did not show for the civil contempt hearing. That turns it into a criminal matter as far as if he doesn't show, that is a criminal contempt hearing. So right now there's 2 hearings to be scheduled if he doesn't show. Another one to be scheduled if he doesn't show, but that's for the contempt hearing. And then another hearing for what's called a plenary hearing, but we'll kind of go over that. So let's read through this. So starts off, this is a matter before the court as a result of the court's order on the amended motion to show cause, entered 19th April 2021. That's how long it's been since we've had the judgment. The court case is over as far as that. It has been ruled upon. The court has decided. And they told Kyle, this is what you need to do in order to comply, right? Directing that Mr. Curtis appear at a scheduled hearing May 11th, 2021 on 10 a.m. and show cause as to why he should not be held in civil contempt pursuant to Section 5A21A of the North Carolina General Statutes for failure to comply with the court's partial judgment by the default. The judgment entered on January 23rd of January 2020. Again, it's been that long since we got our judgment, and he's not done anything since then. Nothing. The court does not repeat, but incorporates by reference the procedural history of this matter as stated in court's 19th April 21 order. So they're not going to review all that stuff. They're just saying, hey, this is all the stuff, the backstory. If you want to go look at it, there's the order for it, okay? These are the matter of finding of facts. Yeah, DA means district attorney, yes. Mr. Kernis, who is now pro se, registered as a party and created an account for filing materials with the court electronically. When doing so, he provided both his email address and physical address. On 3 occasions, Mr. Curtis has filed materials electronically, evidencing his knowledge and ability to use the court's electronic filing system. See order compliance and financial considerations, compliance order ECF 19 or 18. Motion set aside ECF number 19. Motion set aside default J revised ECF number 20. Pursuant to North Carolina Business Court BCR 3.8, Mr. Curtis was notified that the court would transmit all orders, decrees, judgments, and other matters to the court's electronic filing system, which in turn would generate a notice of filing to all counsels, and in this case to him as a pro se defendant. BCR 3.8 makes clear that the issuance by the electronic filing system of a notice of filing for any order, decree, or judgment constitutes entry and service of the order, decree, or judgment. And I want to make that very clear. The sheriffs did go out to his house. That was back in April, and I believe this is my own interpretation. I don't actually have direct evidence of this, and I always tell you guys when I have evidence when I don't. This is just my interpretation, because this is what I gleaned from what my attorney told me. They sent the cops out to have him service, but they wanted to see if he moved, and this was done by not Judge Gale, but actually Judge Earp. So I guess she had been trying to transfer this over for a while. I've known Gale has been retiring for quite some time. Months ago, I knew he was going to retire. So they were probably having a change of some of this stuff for quite some time. Now, other lawyers I've talked to said that's unusual. They say it's usually, here it is, I had it, you've got it. But from what I understand, it was for whatever reason, Judge Earp that had the sheriff's department go out to him, and that was back in April, the notice of the hearing. So take it for what it's worth. But either way, the fact that it got returned does not matter. He was still served, right? So I'm going to read this last part again, make it very clear to some of the people in the back that have a lot of problems with this kind of legal stuff. BCR 3.8 makes it clear that the issuance of the electronic filing system of the notice of a filing for any decree, order, decree, or judgment constitutes entry and service of the order, decree, or judgment. In other words, if he moved, it doesn't matter. If he changes his email, it doesn't matter. As long as he has the original email that we have used and he doesn't change it, he has been properly served. So he had notification of the hearing. It was properly served, right? Anybody who thinks otherwise I'm just going to tell you, is a straight up moron. Big shock, right? All right, so number 5. Neither BCR 3.8 nor the North Carolina Rules of Civil Procedures provide or contemplate that any other form of service is required. Well, there you go. The reason why, again, they sent the sheriffs to his mom's house was to determine whether he had actually changed the address with the court system. They know now he did not. He failed to do so, which is a rule in the court system. So he was properly served. There's no other service required other than notification through the electronic system in North Carolina, which he was. Mr. Curtis has not moved pursuant to PCR 3.2 to be relieved from his obligation to use the court's electronic filing system. That is huge. Because again, if he has moved, right? If he has moved, who knows whether he has or hasn't, because newsflash, Kyle has a massive history of lying. If even he has, it does not matter. It goes to the electronic system that he made an account for, that he has used 3 times at the minimum, that he has understood how to use it. That's all that matters. It goes through that. Okay? I mean, I don't know anybody can read this and not understand otherwise. And this is something I've been saying for a while now. I understand this stuff. I mean, I've been doing this a while. I'm not a lawyer, but I mean, you don't have to be to understand simple freaking legal stuff. And this is pretty simple, right? And when it says something very explicit, like he's been served, that's the law telling you, the court telling you he has been served. While not requiring to do so, and this is critical too, while not requiring to do so, the court made efforts to have the Randolph County Sheriff's Department hand deliver a copy of the court's 19 April 2021 order to Mr. Curtis at his address of record. An affidavit from the deputy who attempted service states that the deputy was unsuccessful in this effort and was informed by Mr. Curtis's mother, who was present at the address, that Mr. Curtis had moved to Raleigh 4 months ago. See Randolph County Sheriff's Office of Return Service, number 60. I was aware of this. Okay. When I asked my lawyer about it, he said it has absolutely no effect whatsoever. And we know why, because of the electronic service. Even if true, Mr. Curtis physically moved. A change of physical address does not affect one's email address, and it is Mr. Curtis's responsibility to provide accurate information and otherwise to comply with the rules of the court. Is anybody surprised at this? This is... You think anybody would have some common sense that's not a complete idiot would know that if you're in a court case, you have the onus to tell the court that you no longer at the address or have different information or that your email has changed? I mean, how dumb do you have to be not to understand that? I don't know. Number 9, the judgment required Mr. Curtis to return administrative control and primary ownership rights of the Non-Sequitur Show podcast, YouTube channel, and other accounts associated with the party's business endeavor to the plaintiff. That's a lot of stuff. That was more than just a channel. Like I said, I've already written the channel off. I hate to tell you guys. I mean, if we ever got it back, sure, I would do something with it. But that's not my primary concern. That's Cheshire's big thing, and I understand why. But I have to be realistic. I don't think Kyle's ever going to give it back, and I just have planned for the worst, that he's just going to hang on to it as long as forever until he dies in jail. And I'm okay with that. I have to think that justice has to be served. Better that he pay by spending years in jail than getting the channel back. That's his choice, and that's what makes it all the better. He can get out of this, but he has chosen not to. Everything he has done has chosen not to, and that makes it all the more relishing, right? Because it's not like we're doing this to him. He's done it to himself. The judgment required Mr. Curtis, the business endeavor is defined in the complaint as non sequitur, a name used collectively for the Non-Sequitur Show podcast and the Non-Sequitur Show YouTube channel. The judgment further required defendant to, quote, provide plaintiff with all the financial documents associated with the Non-Sequitur Show's financial affairs and financial condition within 14 days of the order. Fun fact, that didn't happen. On February 4th, 2020, Mr. Curtis submitted a document entitled Compliance to the Order, ECF number 18. The document included a summary of some financial information, but no original financial documents were provided. See, compliance order. It was not audited. They were fabricated. They were padded. It was misinformation. It was fraudulent. There's no question about that now. And it didn't have any of the original financial documents. It didn't have any of the tax returns, didn't have any of the financial statements, the expense reports, the income statements, the actual evidence from the revenue streams, nothing. And by the way, welcome Schroeder's Cat out there. I do see you. I'm going to put a special shout out to Schroeder's Cat because people may know a few weeks ago, or I guess, about a month ago, I was having some personal stuff. And I got to admit, I was watching Schroeder's Cat's videos and binge watching them, and they were cheering me up, man. They made me freaking laugh. And I respect when somebody's got some good stuff that I enjoy. So thank you for that, Schroeder's Cat. You really had a major effect on me. I'm telling you, I was really, really down there for a while. But all right, sidetrack. I don't want to get emotional. Number 12, prior to the 11 May 2021 hearing, Mr. Curtis did not file any additional documents authenticated by sworn testimony in response to the 19th April 2021 order. Mr. McCrae submitted an affidavit stating his position with respect to the rights and financial information he is due from Mr. Curtis. Now, the court, hi, Vibrant Blantley, I do see you out there. The court offered to have affidavits put in if there's anything that the court needs to know. I did. Kyle did not, right? The court understands that primary ownership rights is the term of art used by the YouTube to determine access and control rights with respect to YouTube channel. The court, in its judgment, did not authenticate actual ownership of the partnership asset. That is true. There's reasons for this. That has to be adjudicated. Not really adjudicated. What it has to be is dissolved. Okay. So what happens in a court case like this, after everything's said and done, and after we're able to ask for the damages, then we have to dissolve the business, okay? And that's when it goes to the ownership rights. Okay, so we already knew about this. We knew about this 2 years ago that that's how it works. All right, so that'll all be done when they dissolve the business, right? Mr. Curtis did not appear at the May 11th 2021 hearing. Mr. McCrae appeared through counsel and was heard. Mr. McCrae contends that Mr. Curtis' prior submission does not comply with the court's judgment. Motion to show cause ECF 23, and that Mr. Curtis has still not complied with the judgment. Among other things, Mr. McCrae contends that Mr. Curtis provided a list of inaccurate usernames and passwords for accounts associated with NonSequitur and failed to provide any financial documents. Yes, that is true. Those were not passwords, and they're all second-party authentications anyways, right? So it wouldn't have done any good. The court has noted this. We have taken that into account and let the court know that just having passwords is not enough to suffice to meet what's called purge conditions, right? Number 4, conclusions of law. Mr. Curtis was served with an order on the amended motion to show cause and notice hearing scheduled for 11th May 2021. The purpose of the hearing was to give Mr. Curtis an opportunity to show cause as to why he should not be found to be in civil contempt for failure to comply with the judgment. He failed to appear. The purpose of the civil contempt is to preserve the rights of the private parties and to compel obedience to the orders and decrees made for the benefit of such parties. And then whatever, I haven't read that, by the way, whatever that citation is. In its 19 April 2021 order, the court found probable cause to believe that Mr. Curtis is in civil contempt. Is in civil contempt, right? Not is possibly in civil contempt. The court has found a reason to believe that he is in civil contempt. At that point, it goes to the contemptor to show the court that they're not in civil contempt. The burden shifts to the contemptor. And then it has the legal citations for that. Therefore, the burden of proof has shifted to Mr. Curtis to show that he should not be held in contempt, that he lacks the means to comply, or that his noncompliance was willful. These are very, very specific 3 conditions. If you go read the statute for civil contempt, which can be 30 days, 90 days, or up to a year, then it can be refiled indefinitely, which we would plan to do. So if he goes to jail for civil contempt, he will basically stays in there indefinitely until he meets the purge conditions. We will file at the end of the year. But those are very 3 specific things that must still be in effect in order to show the court that he still has not complied, and that has to be, like I said, refiled at the end of 12 months. Okay. Mr. Curtis' failure to appear for the hearing, as ordered by the court, particularly when coupled with his earlier future to respond to a complaint, suggests that he has acted willfully to disobey an order of this court. They're well aware that he has acted to disobey the order of the court. This conduct raises the potential for the court to find that Mr. Curtis is not only in civil contempt for failure to comply with the judgment, but is also in criminal contempt for failing to appear 11 May 2021 as ordered. Now, again, we have another civil contempt on the docket. Has not been ruled on yet, and that is for the submission of altered evidence. That is a separate criminal contempt, and that is because that was a willful interference with the court procedure. Right now, unfortunately, the only thing you could do for criminal contempt is up to 30 days in jail, $500, or sanctions, or any combination of that. Obviously, it'll be at least be 30. It'll be the 30 days. Well, that's what we would ask for. But 30 days is insignificant with the as opposed to the civil contempt, which is odd, right? The criminal contempt you think would be worse. No, the criminal contempt is only 30 days. The civil can be up to a year if it then has to be refiled. Were it not for potential for this, and this is important here, and it sucks, but were it not for the potential of COVID-19 concerns in this unprecedented time, Mr. Curtis's pro se status, Mr. Curtis' earlier, albeit insufficient, attempt to respond to the judgment and gravity of the consequences for contempt, which include imprisonment, this court would issue an order of show cause hearing requiring Mr. Curtis now come forward and show cause as to why he should not be held in criminal contempt for his failure to abide by the court's order to appear on 11 May 2021. However, under the circumstances, this is the part that sucks, the court will schedule a second hearing to afford Mr. Curtis a final opportunity to either comply with the judgment or appear and show cause as to why he should not be held in civil contempt. Okay? Now, these are what's called the purge conditions. These are the things he has to do to get out of going to jail. And by the way, it's separate to criminal contempt. He still has to show up and say why he should not be held in criminal contempt, right? But that's separate from the civil contempt. They are 2 different things. Compliance with the judgment requires that Mr. Curtis produce the following information and take the following actions. A, provide all current username, passwords, and multi-factor authentications necessary to return primary ownership rights and channel administration of the Non-Sequitur Show YouTube channel and podcast to Mr. McCrae. Right? So that right there is just strictly with with the channel. Provide original financial documents for all revenue resulting from the Non-Sequitur Show, regardless of the source of that revenue. That includes YouTube, Patreon, Teespring, PayPal, Streamlabs, Redbubble, AdSense, podcasts. That will include all financial documents, including his tax returns. We've asked for the tax returns, okay, and all bank account records, right? So we'll see if he shows the stuff where the money has gone, right? Provide original financial documents for all expenses incurred and paid for the Non-Sequitur Show for any revenue-generating activity relating to the Non-Sequitur Show. Provide copies of all federal, state, and local tax records reflecting income earned from the Non-Sequitur Show and activities related to the Non-Sequitur Show. Provide bank statements for all accounts into which either revenue from the Non-Sequitur Show was deposited or expense for the Non-Sequitur Show were paid. That's huge. Provide a sworn statement made under oath, under penalty of perjury, that the documents and information provided are true, accurate, and complete to the best of his knowledge, information, or belief. Okay? These are pretty significant purge conditions, because basically everything we've asked for is included in this, because we're asking for all the original documents, bank statements, and things relating to the Non-Sequitur Show and podcast, right? And there's a lot of stuff relating to that. All right. Number 20. The court notes that its only means of compelling compliance of a person found in civil contempt is imprisonment as long as the civil contempt continues. And there's a reason. As such, Mr. Curtis should be prepared to place in the custody of the sheriff of Guilford County should he not comply with the judgment and the court make a final appropriate finding of civil contempt. That's pretty huge. Right? I mean, if he doesn't meet the purge conditions, the sheriffs will find him. We will note where he's at. The sheriff, you're not going to escape from the sheriffs. Let's be realistic here. The court, this sucks. This part sucks. The court is affording Mr. Curtis a third and final opportunity to comply with the judgment, and failing compliance, a second opportunity to show cause as to why the court should not find him in civil contempt. Should Mr. Curtis fail to make good use of this opportunity, the court is prepared to move forward with criminal contempt hearings. So basically what the court is saying is, we're giving you one more shot, and then if you don't, we're going to throw the book at you. We're going to do everything. And I'm telling you right now, yes, the DA is being involved. So, you know, he's done that to himself. So nothing really matters at that point to me. All I want to see is him in jail. That's the only thing I'm concerned about. Dissolving the company, because again, even though that there was no adjudication as far as the ownership, I have 100% primary as far as the custody of the channel. We already knew through Judge Gale that it would have to be dissolved, and then because of the fact that he has committed fraud, he loses his partnership. He loses that. It's called breach of what is it called? Was it irreputable breach of contract? I don't remember the legal name. If OPT lawyers out there, maybe he remembers what it is. But there's a legal name for it. But basically, it says the contract is void. The contract is no longer continued, which means the business ownership is dissolved, or will be. But that has to wait until after we ask for the monetary, and we can't do that until he provides the financials. Or if he cannot provide the financials, then we have to give this a guesstimate, right? And I already got a number in mind. If we give a guesstimate, what happens is this: he has three options, I believe, right? The option is that he accepts the amount we're asking for. He asks for a lesser amount and then justifies it with financials, or he says, no, I'm not paying that, and then justifies that with financials. Those are basically his options. The DA has not drawn anything up yet. No, not yet. That would be awesome, but no. I can just tell you the DA is being involved. What's been done on that, I'm not going to just say any more on that. No, it's a very specific type of breach of duty where you can't fix the breach. Just with an R. Come on, all these legal people out there, I totally forget the term. Now you're gonna make me look it up. This is why we have Google. It is called a repudiatory breach. A repudiatory breach that is an actual breach of an innominate term where the consequence of breach is sufficiently serious to give rise to terminate. So a repudiatory breach is basically we're going to terminate the contract, but that has to be done at the very end, you know. All right, so here we go. The court is. Let me read this again. I don't remember right. Yeah. Let me read it again. Anyways, the court is affording Mr. Curtis a third and final opportunity to comply with the judge, and failing compliance, a second opportunity to show cause as to why the court should not find him in civil contempt. Should Mr. Curtis fail to make good use of this opportunity, the court is prepared to move forward with criminal contempt proceedings. Again, that is completely different from the civil. So if he violates the civil, there's going to be charges for that, an order of arrest for that. If he doesn't show, there'll be a criminal contempt hearing, and there'll be an order of arrest for that. Under North Carolina General Statutes 5A11, a court may find a person in criminal contempt for the, quote, willful disobedience, resistance to, or interference with a court's lawful process, order, directive, or instruction, or its execution. Willfulness in the criminal contempt statute means an act, quote, deliberately done and purposefully in violation of law and without authority, justification, or excuse, which he certainly qualifies for. Our Court of Appeals has also stated that the willfulness element of criminal contempt involves more than deliberation or conscious choice, but also imports a bad faith disregard for authority of law, which has happened with dismission of altered evidence and the willful disobedience of not complying with the court order. Number 23. Any criminal contempt other than direct criminal contempt is indirect criminal. Oh, sorry, let me read this again. Any criminal contempt other than direct criminal contempt is indirect criminal contempt and is punishable only after the proceedings in accordance with the procedure required from North Carolina Statute 5A and 15. So this is how it works. Should Mr. Curtis fail to comply with the judgment on or before date of the second hearing, he is expected to appear in person and to show cause as to why he should not be held in civil contempt. This is underlined. I don't think I've seen them underline anything so far, have they? I don't recall. I don't remember. Failing compliance or appearance, the court will issue a second order to show cause, this time for criminal contempt. A plenary hearing will be scheduled, and the court will determine if probable cause exists to issue an order for arrest. What that means is this. If he doesn't show for this next hearing, there'll probably be an order for arrest for the civil contempt. There'll also be a scheduled criminal contempt hearing. At that time, regardless of whether he shows or not, there's a plenary hearing, which is a fact-finding hearing. That is a hearing of where the court says, okay, what are the material conditions that have happened for him to not be in compliance with the court order? And why is he in criminal contempt? It is basically a fact-finding mission of should he be held in criminal contempt. That's all it's for. And that's required, I guess, in North Carolina. And the court will determine if probable cause exists to issue an order for arrest. So it doesn't matter whether he shows up to the order or not. If not this next hearing, but if he doesn't show up to the criminal contempt hearing, it will not matter. There's still a hearing that will be had, and at that time, the court will say there's enough evidence to issue an order for arrest. So, I mean, long term is there's going to be an order for arrest at some point. There's just really no way there cannot be. The sucky side is it's just taking too damn long. It's just all kinds of leeway that's been given. Is it going to bite him in the end? Yes, but at that point, you know, it's very infuriating giving somebody who doesn't deserve chances all these different chances. He doesn't deserve them. He won't comply. He has never given any indication he's going to comply. But the upside is that when he doesn't comply, he will be going to jail for a very long time. Because trying to get the stuff done in jail is extremely difficult. And he hasn't even shown the judge he's made an effort to do anything, right? The court advises Mr. Curtis that imprisonment can be... and you know what's funny is this. He could have turned all this stuff over and then worked out a payment plan, and all this would have been settled. We would have dissolved the business, and everything would have been fine. But no, he didn't want that. And this is hubris. This is narcissism. This is all it came down to be, is that he had such hubris that he wanted to screw the court over, and he thinks he was screwing me over when he really wasn't. For what? What does he gain from this? Absolutely nothing. He's going to prison. I'm not. So, I mean, I don't know how he thinks that's a win when clearly he's going to get an order for arrest, because I can tell you right now, there's no way he's going to be able to meet some of these conditions immediately. It's going to take some time. And he hasn't even made an effort to comply with anything. So what are you going to tell the judge if you did show up? Oh, I still haven't complied? No, it doesn't work that way. But, you know. Number 25, the court again advises Mr. Curtis that imprisonment can be a consequence of failing of either civil or criminal contempt, that he has the right to counsel. Unfortunately, because this is a criminal matter now, they have to, I guess, give him another opportunity to have legal counsel, which sucks because they already gave him that. But because this is turning into a criminal matter, or at least in the preliminary stages, becoming criminal, because there's two factors: the criminal contempt, and there's also the criminality of the perjury charges, the submission of alternate evidence charges, and we're going to be pushing for embezzlement. So. Should Mr. Curtis elect to retain counsel, he should do so promptly. Counsel is directed to file a notice of appearance at least 2 days prior to hearing. Okay. The court reminds all parties and counsels of their obligations at all times to ensure that their contact information, including their physical addresses and emails, are accurate and updated with the court. Conclusion. Wherefore, the court orders that defendant Kyle Russell Curtis shall appear before the court to show cause as to why he should not be found in civil contempt for a violation of the court's judgment at 10 a.m. on Wednesday, May 26, 2021, in courtroom 3G in the Guilford County Courthouse. I guess they are going back to the courthouse. Maybe that's why they waited. It was at, well, no, that's law. No, that is the law school. Yeah, that is the law school, I think. Or at least the law school part of the courthouse. I'm not positive. I only seen a picture of it, but I've never been there, obviously. The parties are directed to promptly notify the court in the event Mr. Curtis produces the information described in paragraph 19 above, which is fine. If he produces all that stuff, I will be happy to tell the court that. It's not going to happen. He's not going to turn over the channel. He's not going to turn over financials. He's not going to turn over his tax records. He's not going to turn over any of that stuff. We already know this. It is so ordered on this day, 13th day, May 2021. Judge Juliana Theo Earp. All right, there you go. So what do you guys think? What do you got? Some questions? I will be happy to answer them as openly as I can. Speak now, forever hold your peace. Again, mixed on this. I'm not going to say this is the greatest thing ever. It is in the long run extremely beneficial to me because, again, my goal has one thing right now, and that's it. And that is make sure that he ends up behind bars. And that is what we're trying to do. And I think that's what the judge is trying to do, too. And maybe not explicitly, but giving him every opportunity to hang himself, kind of, so to speak, right? Because now he's looking at not just civil contempt jail, but criminal contempt jail, maybe two types of criminal contempt jail because of the willful interference with the procedure of the court. And also, now that it's going to the DA, now the DA probably will be involved. We're looking at, again, perjury, submission of multiple counts of submission of alternate evidence, and we're pushing for embezzlement. So we're not messing around. And what's funny is if the DA files those charges, you can't even ask for leniency. I mean, it's like, what are you going to tell the judge? Oh, be lenient with me because I waited 2 years to comply. No, it's you can only play the court system for so long. Eventually, it will bite you in the ass, right? All right, Stillix666 asks, given how long Kyle has been with his counsel, can lawyers say that they're not going to represent him? Well, he doesn't have a counsel. Lawyers can do what they want. They can represent who they want. I don't know any counsel that would touch this case with a 10-foot pole except for a defense attorney, which is what he probably should get. And the defense attorney is going to tell him, one thing: turn over everything, obey the court order, and go in and throw yourself on the mercy of the court. Right? And I'll be honest, that is his best option. I've never had any bad advice for Kyle at all, ever. That is the best advice. And the reason why I give him good advice is because when he doesn't take it, I get to relish in it. And I enjoy that. So, Chester asked if anybody sent the video of Kyle telling court the judge to go F themselves. No, however, we are afforded the opportunity to submit something before the next trial, if we want to. and we are debating right now whether we want to or not. There's pros and cons. I don't know if we are. I don't think so. However, it is possible if we want to, like I said, we can inform the judge, hey, look, he's already made it clear that he's no intent. We would like a ruling upon this now, and we could ask for that, right? So we don't know if we're going to be doing that or not. Let's see what other questions we got here. All right. So, anyways, like I said, I wanted to get this out there. I'm happy with it in the long run. I mean, it sucks. Don't get me wrong, waiting, but doesn't matter. And of course, people are going to spin this a million different ways. We already know this. It's fine. Let them spin it. Doesn't matter. In the end, Kyle's going to jail. That's all that matters to me. Nothing else matters to me when it comes to any of this. Sure, you know, it'd be nice to have money, but I already know that that's going to take a very long time. For him to comply with any of the court order would be really nice. That's going to take a very long time, right? And so, yes, once we get his bank account records, which if he doesn't give them to us, he will spend, you know, in perpetuity time in jail until he turns over his bank accounts, which means we can get money from those accounts at any times. If he tries to hide money, those are different counts, right? So, I mean, he's just compounding one felony with another felony, with another felony, with another felony, right? Atheist Pastor says, for Steve, do you miss me? Because I miss you. I miss you a lot, dude. You're like one of the few guys that I can actually say that I really care about. Because I don't care about many guys. I just don't. You know, there's a few people in my life I care about. I care about Red's rhetoric. I cared, you know, obviously so much about Bull. It hurts. But you, my friend, are somebody that I actually do care about. So yes, I do miss you. Not that I don't love you all. It's just certain people in my life I actually, you know, have in real life kind of thing that I want to meet up with, and Atheist Pastor is somebody who I really do want to have a drink with. Dapper Dino, I'm still disappointed you didn't go after his grinder in your filing. No, that's not. We can't go after. I don't want to go after that. We don't need to. There's so much other things we're going after him for, so it doesn't really matter. Now, like I said, if he turns this stuff over, then we are obligated to tell the court that, and I'd be happy to do so. And the sooner he does, the less chances of him having a civil contempt, but he's not going to do that. Res Instance, 100 Australian. Thank you, sir. Need money? I got some for you. Thank you. That's very kind of you. And I do appreciate Res. You've been a huge supporter of this channel, and don't think that we don't notice that. Most certainly do. And so I really appreciate that, Res Instance. And you know, I tell you what, though, I'm going to do this. First of all, somebody donated $25 to me to go get some whiskey. I haven't been able to get out yet. I haven't forgot about whoever that was. I really do pay attention who says what. And so somebody has said, you know, money for Johnny Walker Black. I will be getting some. I haven't forgotten. But when my first dollar that I ever get from Kyle, I'm probably going to frame, and you know, I got to do something nice for you all. I don't know what. Maybe, like I said, I want to go out and visit people. I want to see. There are so many people I want to go visit. I am taking a little vacation, probably next month or the next. I am going 3,000 miles away, so maybe I can stop by and see some people. But Vibrant Brantley, $2. I care about everyone. You know, no, I do too. You know, I do. But you know, when I say that I love somebody, I mean it's not just words with me. I mean I really care about them. I'm not in love with them. But I mean, if something happened to them, I would just be emotionally distraught. I mean, I was wrecked over Bull. I mean, I didn't show it because I wasn't on, you know, air. But I mean, don't think for a second that didn't devastate me. I mean, he was one of the greatest men I ever knew. I mean, I of course I loved him, and losing him was beyond measure. And the way that people used it as a weapon was beyond vile and morally reprehensible. So, you know, it sucks. Oh, but I do have this. Just to let you guys know, I did tell Ruhif, should anything happen to me that I die, I want your promise that you will pursue Kyle to the ends of the earth to make sure that he ends up in jail. So I have that. So don't worry. If I die, Kyle's still going to jail at some point. For how long? That's the question. That's completely up to him. Helios, welcome to New Hole. Thank you, Helios. You're in New Hole. I don't know why I came up with those. New Hole, A-hole. I don't know what it was. Call it. Thank you. And by the way, I hope you guys have been liking some of the stuff I've been doing. I've been doing with these reviews and, getting back into the, discussing evolution and biology and some other things. So since I'm not getting Non-Sequitur back, I've already, like I said, I've already just written that off as far as him ever giving that back. I am going to be doing a lot of stuff on this channel instead. Jessica and I have a great show that we really enjoy doing called Judgment Call. It is 10 a.m. on Mondays, and it has been very successful, I think. Matter of fact, last show I had told her, I only think about doing this for about an hour because I'm just not feeling it. And we said, okay, we'll see how it goes. And, if there's not a lot of callers, we're ended in an hour. 3.5 hours freaking later, or 3 hours later, whatever it was. So it's been awesome. So I've really been enjoying that show. Zach had asked how Boulanger died. It was from natural causes. We'll leave it at that. Negative Exponent says he doesn't seem to mind going to jail. Well, yeah, he's been there how many times before? He's had file failure to appears. I would have those documents in the court's hands the day after they ordered me to. I'm not going to spend one in jail over YouTube channel. Well, maybe you're not as much of an idiot as Kyle is, right? I mean, even if, no matter what Kyle had done, if he turned all that stuff over, he could not be held liable for civil contempt. No matter what the bank records showed, right? They're going to be found out anyways. If he gets filed for the DA for embezzlement, they're going to ask for those court records anyways. So what the hell is he waiting for? I don't understand his reasoning on that. The documents have to be turned over at some point, regardless, whether it's from civil contempt, whether it be from prosecution for his submission of alternate evidence, or perjury, or embezzlement, or whatever it is. At some point during this case, he has to turn over the courts, or he sits in jail until he does, period. Why would you want to waste your time on that? You might as well get it done and be over with. And I don't understand, because now it's just compiled. He would have never been probably found out about the altered evidence and all that other stuff if he hadn't been prolonging this. He would have been over and done. He would have lost. He would have, made a payment plan or whatever, and we would have moved on with our lives. But nope, that wasn't good enough for him, because his ego and his narcissism was too great for that. And he was like, I'm not doing any of this stuff. Fuck the courts. And, well, the courts are going to fuck him back. So, No Faith says, we'll bet that Kyle does not go to jail. Want to bet $100 on that, No Faith? I've already got $100 on that with, who is it? Peter Riley, who wrote the blog for the Forbes.com. Either he'll go to jail or he'll at least have a arrest warrant. That's the condition. I asked Peter if that's good enough, because if he gets an arrest warrant and he runs, it's going to be hard. But yeah, he will have an arrest warrant at some point. No Faith. I'll bet $100 on that with you if you like. Let me know. Email me. SteveAskAnything@gmail.com. Rodin's no last name, $5. Do you think the judge will have police prepared at his home and work just waiting for the bench warrant to issue? No, that's not exactly how it works, unfortunately. There are ways of going about doing this, but the police department knows where his mom lives, obviously, and they will be able to go down there and basically we'll find him. We will find him. There's no question about that. I know Rivard already said he'll search the fucking planet to find him and bring him to justice. There's no way he can outrun that. Let's see here. Kevin Stern for $2 just because I don't like Kyle. Thank you. Sheena Living Water says, why not Non-Sequitur 2, new improved? There might be something along those lines in this channel, maybe. I have clicked around ideas. The thing is, it's difficult because I really like this judgment call with Cheshire, and I don't know how much redundancy it would have if we start doing a Non-Sequitur show type format as well, right? But we might, if she's up to doing 2 shows, a week kind of thing, because I don't want to give up the call-in. I really enjoy that. But the Non-Sequitur, the what I have in mind, which is completely different than the crap that Kyle wanted to put out, because his idea was completely stupid. He took what we had and just wrecked it. It was all, his vision was crap, absolute crap, and this is why nobody wanted it. We have a better vision, I think, and so we might see in Living Waters. That's why it really doesn't matter whether we get the Non-Sequitur Show channel back or not in that regard, because Cheshire and I are doing very successful on this channel, and she's doing very successful on her own channel, right? I mean, sure, we don't have 27,000 subs, but you know what? I've got 17,000 almost, and you know, I have a following, and I have people that I care about, and people that care about me. What else matters? And I love my subs, and I love people that, you know, have supported this channel and Patreon. So, you know, I don't know really what good it would do to get the NonSequitur Show channel back at this point. There's no revenue stream from it. It's frankly dead. Kevin Stern, $2 just because I don't like Kyle. I've already read that. He still, by the way, Kevin Stern still doesn't like Kyle. Somebody asked me, was pink the first color on Earth? Pink isn't a color, believe it or not. There's no wavelength for pink. Yeah, fun fact. Still like 666, 2 pounds. Thank you. Still like 666. Kyle equals piece of shit. Yes, we do know this. And again, I don't even understand what the hell he ever thought he would ever be able to get away with this. From day one, when I had said, "Hey, look, this is a bad idea. When people find this out, they're going to be the channel's going to be destroyed. You're basically shooting yourself in the foot, kind of stuff." And he didn't want to listen to that, right? Exploratory Minds Project, 10 pounds. Have yourself a drink on me. Thank you, Exploratory Minds. I do appreciate it, and I will. I am getting a bottle of Jack. I have to wait for my roommate to come back. He is in Oregon. No, wait, Oregon? Yeah, I think he's in Oregon. He should be back the next day or so, and then we'll go to the store and I'll get some Johnny Walker Black. Throw the drawer. So many things. There's throw the drawer. Throw the drawer from the House of Torg. Dude, you've got to tell me what the hell that stands for. Please. $2 Australian. Just ask the judge to make YouTube give it back. We can do that if we wanted to. The problem is, if we do that, that's one less purge condition for Kyle. Right? And the court doesn't want to have to do that unless there's no other options. And we don't want to have to do that route yet. We could have, but we decided not to. Res Instance 20 Australian. Remember, people, Kyle wanted this. Sue me. Direct quote. Correct. Yep, exactly. Sue me. Direct quote. I mean, so we did. He lost. He exceptionally lost. And let me ask you guys this real quick. If Kyle was so sure that he was going to win, why didn't he show up? If he was so sure that he had a case, why did he fabricate evidence? Everything I submitted was absolutely 100% true. Nothing was fabricated. Nothing was altered. Nothing was forged. Nothing was photoshopped. It was all information that is readily submissible with evidence. I really want to know that. I really want to know what the hell somebody who ever thinks that Kyle in any way was in any way honest and from day one on this, when he went out of his way to lie to the court, that he went out of his way to put bank records in from an account that did not even exist on the date that was on it, because he changed the date, which, by the way, was, again, Rift and Astronomy Live discovered through their, ability to go in and look at the PDF, which was 100% correct. We knew that he had altered this stuff. The courts know that he has altered this stuff. But yeah, I mean, nothing I have submitted has been in question with the court. Nothing. AKA Hereticals, FKA Atheist Pastor, 5 Australians. Since we can't have a drink in person at the end of the moment, at least I can do is buy one. Thank you, sir. And I will, again, drink with you guys. Scott, Johnny Walker Black, as soon as I can get it, hopefully this weekend, before this weekend. We'll have a rum and coke midday, because, well, no, I guess we have an evening time. That's midday for Australians. I know that you guys cannot travel yet, and it sucks. I want to get Ruhif out here. We're supposed to play some poker. But let's see here. Vibrant Brantley, is Steve saying the police are going to hold Kyle's mom hostage? Because that's the awesome, but very unlikely. No, that's not what's going to happen. Overnator, I thought Kyle probably thought Steve wouldn't spend the money to sue. Well, unfortunately, Kyle didn't recognize the fact that we have a very good friend that I adore, that who is a very in real life friend of mine, who is very well off, and he wanted justice done. Kyle was not expecting that. And Ruhif has a very high sense of ethics, and he wants justice. He wants Kyle to pay for this. And I think that the Non-Sequitur show fans do as well. Because what Kyle doesn't realize is that it's not the Non-Sequitur show fans that have supported him. It's trolls and people that don't know how to understand things about the law that has supported him and led him astray by giving him misinformation. Because everything he's been told has been determined to be wrong. I mean, they were wrong about the service. They were wrong about everything so far, right? I mean, you had people out there going, oh, look, he wasn't served properly, when me and Roof going, yes, he was. Roof was willing to bet like $100,000 on it. He was going to bet $1 million on it. We knew that he was. Nobody took his bet up. I was going to bet thousands of dollars. Nobody took me up on that either. I would have blown every dime that I had. Yeah, I would have starved to death if I lost, right? I mean, but it would have been worth it because, I mean, I'm convinced that he was served right. And they weren't. And because the law, they didn't understand. And who was right? I was right. And so they're giving Kyle bad information. Vegan atheist Coral for $5 for Bull. Thank you. And you can't see me, but I'm toasting Bull right now, even though it's coffee. Attila the One, $5, quote, his ideas were completely stupid. As a Patreon, this was so true. Tell it like it is, Steve. Hell yeah. Excited to see what you come up with next. Thank you, Attila. And I know you've been around for a very long time as well. And I appreciate it. Yes, his ideas were dumb. There's no question about that. Mr. P says, last time I checked, the Non-Sequitur show, despite being dead, was still getting more views than Steve and Cheshire combined. That's irrelevant. Views are not what matters. The support is on this channel right now. The support is on Cheshire's channel. All these people that are donating to the channel, those were Non-Sequitur show fans. What's the difference? It's not about the views. I don't care if I get 100 views or 1,000 views. What I care about are people supporting the channel. Is it they are enjoying the content? Is it what they like to see? Are they being entertained? Am I putting out correct information? I am not looking for views when it comes to, it's just about the views. No, of course not. Now, we all want to get views. I mean, why would we be doing this if we didn't want people to watch? But that's not the metric that is a primary consideration. It's just not. The metric to me for primary consideration is how many people have supported me, Cheshire, and other people. So that to me is the true metric. Dargus 890, $5. Kyle singing, I found the courts and the courts won. Oh, I fought the courts and the courts won. I fought the courts and the courts won. I know I can't sing. Tatatron says, first, don't assume Kyle was thinking. This is true. Ash says, some were non-sec fans. The ones who arrived right at the end was becoming an LGBTQ show. Yeah. And by the way, that would have been fine. I support LGBTQ+. I'm completely. However, you can't make that your entire shtick about the channel when the channel was not about that. He turned it about himself. He made the entire channel about himself. It was his ego. And about LGBTQ, right? We didn't want a Mr. Atheist show. He did. I was like, no, this is not an atheist channel. This is not an LGBTQ+ show. Doesn't mean we don't support him. Of course we do. But he wanted to be like Mr. Atheist, a lying piece of crap. So, Attila the One, I didn't mind some of the LGBTQ content, but dear God, did that show move away from the science philosophy so hard? Yeah, because Kyle didn't understand that stuff. I remember thinking that someone was odd just prior to implosion. That something was odd just prior to implosion. Yeah. Well, I mean, we did all we could. I'm telling you, me, Reds, and Bull did all we could to get the financials. And let me tell you very straight out, Kyle never offered me a dime. I went to him and said, I want $1,000 a month as a draw because we're partnerships. He said, yeah, let me get clear of that with the CPA. Never got back to me on it. Why? He never had a CPA. That was me going to him. I have this in email. I have this in writing of this discussion. He has never offered me a dime, though. The only time he did, obviously, when the Death of Non-Sequitur show, do you want your money? Well, of course, but I want to see the books. How much you owe me? This has been the whole point. How do you have the financials and lie about having a CPA you don't have? You've been stealing the money. You've been embezzling the money. That's the whole point of the freaking lawsuit, to show that he stole the money and embezzled it and used it inappropriately. It's called financial conversion. He's already been found liable for financial conversion. The criminality of that is, the equivalency is called embezzlement. Again, that's a different charge to the DA. Judilla Music, $5. Do you think this could be a landmark reference case for future, Steve? Possibly. There are things about this case that even my lawyer has never seen before. So it might be something that might have some precedence, yes. Yeah. Red says, I actually discovered Steve's channel first through the after-show discussions before I discovered NonSequitur through those very videos. Yeah, well, I've had people, yeah, and I appreciate that, man. I've had people on this channel for 8 years. I still come around from the very first video. Ovinator, I have a question. I know that Kyle told Steve to give him administrative control of the NonSequitur channel for search engine optimization, and Steve was tricked. What was Steve thinking? I didn't know anything about SEO. And I didn't know what he needed to do. I had no idea. I was like, okay, that's fine. Do your thing. He's like, I'll take care of everything on that end. Okay, whatever. I wasn't thinking he was going to fuck me over, right? Now, hindsight, sure, I should have retained control of it, but I had a partner. I was like, it doesn't matter who has control of the channel. Why does it matter? We're partners. 50-50. He knew this. Right? And by the way, no, I never told anybody we had a written contract. That's an absolute lie. What I said was we have a verbal contract that's supported in writing, which is the case. It's called a handshake agreement and is perfectly legal. Nothing wrong with that. But we never, and Kyle never offered me a contract. I mean, where is that evidence for that? I've never seen anything contractual wise that he's offered. Nothing. There was a DBA that we decided we didn't want, an LLC that we didn't want. And that was his decision as well. He didn't want to go that route. And if anybody can go ask Dave McGinnis, he was in those conversations. So it wasn't just me that didn't think it was necessary. We didn't think it'd be that successful. We're like, we don't need this. It's just at this point, nothing we need to do. If we want to do it later on, that's fine. But so we decided not to have the DBA and the LLC. That was both of our choice. But he never offered a contract because there never needed to be. We have, okay, here's our verbal agreement. We've got it in the emails. That's fine enough. That's all you need. Let's see here. Calling Mr. Atheist Pastor, calling Mr. Atheist a lying piece of crap is insult to a lying piece of crap. You ain't getting on that. Yeah, he lied his ass off. When he said that he did not know that we weren't partners and that Kyle couldn't remove him from the channel, he was outright lying to people because he had been in those discussions with us. So I know he lied there. So anyways, we're going to wrap it up. So this is kind of where we stand. He's been given to the 28th. Unfortunately, there's not much else we can do. There's a couple hearings. We can't ask for any money yet because they haven't given the financials. We can't ask for dissolution. When we ask for the dissolution, basically at that point, he's no longer associated with NonSequitur show. And he'll have to make restitutions to myself and Ruvif by some means because he cannot do so. He cannot file bankruptcy. You cannot garnish wages. However, we can do many other things to get finances out of him. As long as he has income, we can get revenue, and we can do that for 10 years, and we can renew it after the 10 years, right? So. But yes, we are asking. We'll be asking for dissolution after everything's said and done. One last question: if Kyle had not legit moved at his mom's, has she had not acted as agent, thus removing papers that was served confession, would the service been good? As long as they were serviced, as long as somebody signed for them at the last known address, then it would have been good, right? It doesn't matter whether he moved or not. That was the whole point. It didn't matter whether he moved. And he was told this. I'm sure his lawyer told this. I mean, his lawyer left because she did not, he was not taking her advice. And it had nothing to do with finances. It was under Rule 1.16 B 1, 4, 7, and 10. That has nothing to do with not being paid. That would have been 1.16 B 5 if he didn't get paid. And so it wasn't because of that. It was because of a conflict of interest, because had the lawyer continued, she would have had to lie to the court, and she cannot do that. So it was called a conflict of interest. What they do at that point is they say, hey, Your Honor, I cannot continue with this. Don't ask me why, because she has a it still has an obligation to the client. She can't breach, confidentiality. And generally, the judges go, yes, we realize we can't, really ask you much detail about it without breaching your confidentiality. There's no reason to keep you here, and we basically will let you withdraw. Throw the Dwarf of the House of Torg for 5 Australian says, Throw the Dwarf is from Globers and Goblins, and House of Torg is from Dapper Dino D&D channel. Oh, okay. I gotcha. That makes sense. So Cheshire, do you want in on this? Anything? Do you want to add anything? Do you want to come in for a minute and put your 2 cents on this video? I want to keep it short. It's under an hour right now, but if you want to come in, let me know. Ticketron says, yes, lawyer cannot knowingly lie to the court and cannot knowingly allow their client to lie to the court. Correct. Now, again, I don't watch any of the people that spin this shit. I just don't until somebody sends me a clip. Then I go, but just recognize that people are going to spin this. We already know that, right? And they're not understanding any of the legal stuff from people that don't understand the law. So I just tell people, look, you can listen to myself and Ruhif and Reds that have been absolutely correct on everything we've told you guys so far. I've been keeping you guys abreast. I even said there was going to be an order in the next couple of days. I even said it's going to be criminal aspects to it. I even said that Kyle's lawyer was going to withdraw. I already said that the service was good. Everything I've told you guys has been the case. Nothing has been incorrect. It just has been taking a lot longer. So, yes, there will still be an arrest warrant. I thought it was going to be last time. Got that wrong. Yes. But it's just been postponed 2 weeks for that. So, in the long run, I still believe very strongly. I'm convinced that there will be an arrest warrant at some point, but it won't be until, less than 2 weeks from now. Chester doesn't want to come in. All right. Thank you guys for watching this. If you got questions, please leave it in the content. Leave your comments in the video section, but yeah, unless there's anything of interest, don't bother sending me clips from these trolls. I don't care. I just don't watch it. It doesn't matter to me. They're placating to their audience, and that's fine. Let people be stupid. I don't care. The end result is Kyle's going to prison, and that's all that matters to me. Right. And you guys, obviously, I love you guys. I appreciate the fact that you guys have been so supportive of this, and you guys have been following along with this. Like, it's actually like part of your guys' life story as well. Right. That's amazing to me that this case has been in our lives for 2 years. 2 years, people. And you guys have been stuck by it. So, props to you. And by the way, I'll leave you guys with this. All you guys that are listening in that have been supporting me, you guys were all right. You ended up on the right side of this stuff. That should make you feel pretty good, because the other people that didn't, their reputations are shit. They supported a person who had a fraudulent GoFundMe for a lawyer to basically lie to the court. They supported somebody who stole $60,000, didn't pay his partner. They supported somebody who committed multiple counts of perjury, forgery, and embezzlement. Right? Now that has yet to be determined. Obviously, can't say that those have been proven yet, but they have yet to be determined. But I can say that they definitely supported somebody, because it's already been in court as found to be true. That they supported somebody who committed fraud, fraudulent conversion, unfair and deceptive trade practices, breach of fiduciary duty, and breach of contract. Those are in evidence. What do you want to know about those kind of people that support people like that? Especially when, Kyle has five failures to appears, plus he's been incarcerated before, had felonies before. He's not going to show now. We already know he's not going to show now. I will make a $100 bet for the first person who wants to. I already have one out there. I don't want to bet too much because weird things happen. $200 is about my limit right now, but we'll go for that. No, I think he has 5 failure to appears. But, yeah, it's been 2 years. In June, this started. Yeah. Yeah, I've read the comments for the GoFundMe. They're freaking hilarious. I'm thinking of these people. These people gave money to a fraud. They gave money to a fraud, an actual con man who lied to the court. Literally lied to the court. I mean, what the hell? So... anyways, I'm going to wrap it up. My voice is shot. I want to keep it an hour. Thank you guys for watching, and we'll see you later. Good night.